Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The court calls 383A19 Newman versus Stepp. Mr. Tarleton.
Good afternoon. May it please the court, Chief Justice and Associate Justices. My name is Boone Tarleton, and I represent the defendants, appellants, Heather and James Stepp, and I would like to reserve 5 minutes for rebuttal.
You may.
I want to begin by acknowledging that the underlying facts which give rise to this case are unquestionably some of the most tragic imaginable. And there is absolutely no doubt that these plaintiffs have suffered a devastating personal loss. However, the issue before your honors is not whether these plaintiffs have stated a valid wrongful death claim, but whether they have stated a valid negligent infliction of emotional distress claim. What this case is really about is the scope of NIED claims in North Carolina. More specifically, this case is about how far removed in space and in time a plaintiff may be from a negligent act which results in injury to a third person before that plaintiff is permitted to assert a claim for NIED. The defense is asking this court to hold, consistent with past precedent, that a plaintiff who is neither in close proximity to nor personally observes a negligent act which results in injury to a third person does not have a claim for negligent infliction of emotional distress. The crux of this case involves the application of the so-called foreseeability factors first described by this court in the Johnson versus Ruark obstetrics case, which is a 1990 decision. Just briefly, the facts of Johnson involved a parent plaintiffs who asserted claims of medical malpractice in relation to the stillbirth of their child. And in addition to claims for wrongful death, those parent plaintiffs brought claims for negligent infliction of emotional distress as well. The Johnson court embarked on a long historical analysis of the history of NIED claims in North Carolina, and ultimately it came to the conclusion that a physical injury to a plaintiff is not required to assert such a claim. In other words, a plaintiff may bring a claim for emotional distress due to concern for a third party who's injured, but with, however, some significant limitations. Those limitations are essentially the foreseeability factors that the Johnson court lays out. And the Johnson court identified three such factors. Number one, the plaintiff's proximity to the negligent act which resulted in injury to the third person. Number two, the relationship between the plaintiff and the third person for whose welfare the plaintiff is concerned. And number three, whether the plaintiff personally observed the negligent act which resulted in injury to the third person. The Johnson court did emphasize that this is not an exhaustive list. However, all those factors are important and all must be considered on a case-by-case basis. None of them should be disregarded. In applying those factors to the facts in hand in Johnson, the court in Johnson allowed the NIED claim to proceed in that case for the exact reasons why the claim should be denied in this case. In the Johnson case, as I stated, the plaintiff parents were essentially bringing medical malpractice claims against various medical care providers that they were alleging were at fault in the stillbirth of their child. So the plaintiff parents in Johnson were obviously in close proximity to, in fact, in the very same room as these allegedly negligent acts of medical malpractice occurred. They personally observed these allegedly negligent acts. And for those reasons, the court in Johnson allowed that claim to proceed. In this case, the plaintiff's allegations rely predominantly, if not solely, on the existence of the parent-child relationship, and seek to de-emphasize and disregard the other two factors, the proximity factor and the personal observation factor. However, we know from subsequent cases, in particular Hickman by and through Womble versus McCoyne, which is a 1994 decision of this court, and the Anderson versus Bacchus decision of this court, that the parent-child relationship standing alone is insufficient for plaintiffs to properly allege a claim for negligent infliction of emotional distress. The prior decision of this court that is most on point and most helpful and most similar to the facts at hand is the Gardner versus Gardner decision, which is a 1993 decision. And the way that the Gardner court framed the issue in that case, I think, bears repeating. So I will read the issue in the Gardner case as presented by the court. Quote, whether a mother who is not present at the scene of a car accident in which her child is injured may recover for negligent infliction of emotional distress, NIED, when she suffers mental anguish upon being informed of the accident, rushing to the hospital where she observed resuscitative efforts by emergency personnel upon her child, and later learning of her child's death, end quote. If you substitute the phrase accidental shooting for car accident, that is virtually the exact issue that is presented in this case.
How critical is the fact situation here that the plaintiffs acknowledge that they only saw their deceased child after the child had passed? Yes, Your Honor.
I believe it's significant. Perhaps more significant, though, is the factual a situation that's laid out in the pleadings, that the plaintiffs here were not in close proximity to the negligent act that resulted in the injury to the child, nor did they personally observe the negligent act which resulted in injury to the child. So I believe those two factors are most important. It's potentially also relevant that they, the plaintiff parents in this case, did not see or observe their child until after the child had died. In fact, if you look at some of the prior line of cases, the Gardner case, the Anderson versus Bacchus case, and the Hickman versus...
Let me just stop you there. What's really interesting about this case legally is you have the added factual wrinkle that the plaintiffs entrusted the care of their child to the defendants. And it seems to me that's an element that really has not been present in any of our former negligent infliction cases. Am I wrong about that?
Yes, Justice Davis, you are correct about that, at least in terms of that is not a factor in the Anderson case or the Hickman case, but I believe that it is potentially a factor in the Gardner case. The full name of the Gardner case was Gardner versus Gardner. It was actually the mother brought suit against her spouse or former spouse, who was also the child's father. And to more fully describe the facts in Gardner involved a single car accident in which the father of the child that was injured, it would appear, ran into some type of structure, guardrail, bridge abutment, something like that, which resulted in the injuries and ultimately the death of the child. And the father driver was the defendant in the case. The mother of the child, who was not in the vehicle, brought suit against him for NIED. So there was that added element of Gardner that there was that prior relationship, between the plaintiff and the defendant. In fact, they had a child together, and the child, that they had together was the subject of this NIED claim. Further, in Gardner, this factor was not discussed in the Johnson case, but in Gardner, the court pointed out that there was no allegation that the father defendant knew the mother plaintiff was subject to an emotional or mental disorder or other severe and disabling emotional or mental condition. So even though there was this prior relationship between the plaintiff and the defendant in the Gardner case, the court in Gardner still held that that wasn't enough to pass the Johnson foreseeability test or to overcome the lack of close proximity to or lack of personal observation of the injury to the child. And that's a similar situation that we have in this case. We don't have...
I appreciate your answer, but let me just step in for a second. But what's a little different here from Gardner is that, as I understand the allegations in the complaint, and we are at the pleading stage, right? This is not summary judgment. As I understand the allegations in the complaint, it's that the plaintiffs paid a fee to the defendants. So there's a duty of care and a contractual relationship. Does that not matter at all to the analysis?
Yes, Your Honor, that is there is that allegation in the complaint that there was a fee paid. I don't know if we've, given the posture of this case and this, well, you know, we're on appeal from a decision on a motion for judgment on the pleadings. I don't know if we've really been able to flesh out that part of the case. And frankly, I'm not sure how the contractual issue might be at play here, at least in terms of you know, today, you know, that allegation has to be taken as true because it is in the complaint, and this is on a decision on a motion for judgment on the pleadings. And quite frankly, I haven't looked into that issue or briefed it. I don't think either party's briefs addressed the potential issue that might bring forth. And I think the main reason is we simply haven't fully developed the facts regarding the exact circumstances that this child happened to be in the care of defendants at the time, you know, that this happened.
But, you know, given the egregious nature of what's been alleged, is it really a stretch based on our prior case law to say it was reasonably foreseeable that if a parent entrusts their young child to a third party who allows a loaded gun to be, you know, present and unsupervised, that ends up fatally shooting the child, that it's not reasonable that severe emotional distress would occur?
I would agree that in the ordinary sense that we normally use that word, foreseeable, yes, that is foreseeable. And perhaps it's unfortunate that the Johnson court used the term foreseeability and laying out its multifactorial analysis, because I think what the Johnson court is really getting at is not foreseeable in the sense that we would normally use that word in everyday language, but it's a means, this multifactorial test is a means of having some reasonable limits on the scope of defendants who might be liable for this type of tort in North Carolina. So yes,
one last question, and then I'll stop talking and let my colleagues ask questions. It's your argument that there actually in order to get your foot in the door on a negligent infliction claim, the plaintiff actually has to see the negligent act occur? Is that an actual requirement?
No, I do not believe that it's a requirement such that it would be an element. The Johnson court clearly emphasizes these are factors, not elements. So I don't know if it's a hard line. I don't believe that it is a hard line requirement for a plaintiff to see a negligent act. But what we're asking for is for the court to be consistent with its application of the Johnson analysis as it's been applied in Gardner and other cases.
Let me jump in here and ask you about that. If the list of factors in Johnson is not they're not elements and it's not exhaustive, what is it about the Johnson factors that you would contend makes it so that foreseeability would not be for the jury here? Are you treating those factors as if they're requirements or elements, or which one of them and how would you say makes this not for the jury?
I don't. It's not our position that all these factors have to be met in every case. However, in the Gardner case, for example, that case was decided on summary judgment. The Anderson case was decided on summary judgment. The Hickman case was decided, I believe, on a motion to dismiss. So in each of those cases, none of those factual scenarios did go to the jury in those cases. They were all decided by a trial court prior to going to a jury. And I'm not asking this court, and it's not our position, that the court change the test to make the Johnson factors elements. Rather, we're asking for the court to be consistent with its analysis and how it's applied those factors under facts very similar to the ones we have today.
Well, let me rephrase it a little bit. What is it about the factors or the Johnson analysis or even Gardner or the other cases that would mean that this case should not go forward from the pleading stage to discovery and possibly to summary judgment, if not to the jury? How is it that you apply those cases to say this case doesn't go farther unless you say that they're required factors or elements?
So in setting out the Johnson foreseeability analysis, this court said that these are factors to be considered by the fact finder, and I believe the language is where appropriate by the jury. Our position is, given this court's past precedent, given its rulings in the Gardner case, in the Anderson case, in the Hickman case, that there's no reason why a different result should apply. There's no way to factually distinguish those cases. And true, some of those cases were decided on summary judgment rather than on the pleadings. But nonetheless, it really came down, those cases, to what had been alleged and where the plaintiffs were in relation to the accident or the injury, the act giving rise to the injury, how close they were. In this case, that's all basically laid out in the pleadings, and a similar result should apply. I hope I'm answering your question.
Well, I'm not sure. Does it make sense that unless you say it's a requirement of law, that a parent of a young child has to have been present if their young child is shot accidentally by a young child getting hold of a loaded gun that's left nearby, that it's not foreseeable that parent would be distraught?
Yes, again, and the ordinary use of that is certainly foreseeable. I would go and point to the proximity factor.
I was going to ask you about that. What do you think the court means by proximity?
The way I interpret that term proximity, obviously the personal observation means exactly what that means, either directly sensing, hearing, seeing the act. Proximity, in my mind, means either present at the scene or coming upon the scene shortly thereafter, basically witnessing and perceiving the immediate aftermath of what happened. That's how I interpret that term proximity. So no, I don't believe that it's a requirement that a parent has to actually witness an incident like this to state an NIED claim. Certainly they would have a wrongful death claim regardless. But if they're not there to directly witness it, then certainly how close they were in time and space, whether they came upon it shortly thereafter or instead, went to another location, such as a hospital or some other location. I think that is certainly a factor. It was a factor in the Gardner case, and I believe it's a factor here as well.
I guess what is a little difficult to figure is how, if you don't have to be present, because that's a different factor, then how do you apply this if you're not on the scene? What's close enough? Is it across the street or around the corner or across town? I'm not sure how you would apply that. What do you think? That's why I was asking, what do you think the courts mean by proximity? Does it mean proximity of relationship and involvement with the family or the house, a place where it happened? I'm not sure I see how how we can sort of apply that in different contexts.
It's certainly not a bright line test. So it is something that I think a different case might present a closer call. The instance that you hypothesize where someone is right around the corner or outside, I do think that does present a much closer call in applying the proximity factors and applying the personal observation factors. In the hypothetical situation you posited where someone is across town, I think that's less of a close call because, again, something that happened and or proximity that is not very close to the act or the injury
I guess what I'm not, what's not
and-
clear to me is what's not clear to me is if you don't have to be present on the scene, and I guess don't have to be close enough to hear what's going on, then why does it matter whether you're a block away or 6 blocks or a mile away, or on the other side of town? I'm not sure I follow the logic of why that would affect how distraught you are as a parent, or how foreseeably it would be that a parent would be distraught.
Yes, that's a very good question. Thank you. And plaintiffs in their brief do devote some large portions to the argument that this emotional pain is the same whether one actually witnesses the injury or learns about it after the fact. Lines could differ on that, but more to the point, the court in Johnson and in those subsequent cases implicitly is recognizing that IED is directed to a much more specific category of injury than the loss of society, comfort, etc., that's specifically addressed and recoverable under the wrongful death statute. In other words, learning secondhand that a loved one has died is a different experience and a different trauma than personally observing it or being in close proximity to it. And there's an implicit recognition in this line of cases that wrongful death and NIED are two separate and distinct torts with two separate and distinct types of emotional injury.
Is it your position that Gardner is controlling here?
That is correct. Yes, Your Honor.
Negligence usually has as a major component an aspect of a reasonable standard, one acting reasonably. In a circumstance like this, negligent infliction of emotional distress, on the pleadings here, since the decision was made on the pleadings, why not allow a jury to have the usual assessment of what is reasonable under the circumstances in terms of evaluating negligent infliction of emotional distress in a case like this?
And yes, this court could absolutely make a decision to allow that determination to go to the. I don't do that and also uphold Gardner and Anderson and Hickman. In other words, I don't think there's any way to allow this set of facts to go to a jury without expressly returning and possible cases as well. I do think that there's strong public policy reasons for adhering to those precedents. I believe that overturning those cases would essentially allow NIED claims to be brought in every situation in which a person gets a phone call, one has been involved in an accident and rushes to the hospital. All too frequently, society, unfortunately, I think that would lead to an inundation of NIED litigation.
But okay, can I just ask you a question about distinguishing? Sorry, Justice Earls here. Can I ask you a question about distinguishing Gardner?
Yes.
Because it does seem that not only is the fact that the parents they entrusted their child in a way that different from just one parent, a child being with one parent versus the other parent, and so there is that contractual relationship here. But it also seems to me that if you are right that this multifactorial analysis is not only about foreseeability, but also about keeping this tort narrow to specific and unique circumstances. Doesn't that also then call into question the riskiness of the behavior that was engaged in? In other words, in Gardner, the child was driving in a truck with his father, which is really different from being in a kitchen with other children and a loaded shotgun being on the table. So even before the injury, you have a pretty distinct difference in the behavior, and that seems to me it would bear somewhat on the foreseeability that if things go badly wrong, there will be extreme emotional distress from it.
Yeah, I do agree that there are certainly factual differences between this case because it does involve a firearm and these other cases, which are predominantly car accident cases. With respect to the NIED tort, though, our position is that factual difference does not make a difference to the foreseeability analysis laid out in Johnson. So it is a factual difference, but not one that's relevant to the NIED analysis. Madam Chief Justice, I'd like to reserve the rest of my time. That's okay.
You may. Mr. Jackson?
Mr. Jackson, you are on mute.
Were you able to hear me?
I can hear you now. Go ahead, please.
Okay, thank you. I would just like to clarify something that was in the pleadings, that the parent-child relationship itself doesn't give rise to the intentional infliction of emotional or negligent infliction of emotional distress, and would call the court's attention to record page 5, paragraph 6, record page 7, paragraph 28, which sets out the relationship between this child and his parents, which I think should lay that issue to rest. Now, when you talk about emotional upset and distress, one asks themselves, where does that come from? And of course, it comes from the brain. And parts of the brain involved are the cortex and the, I guess I'm going to flunk my medical school exam, the cerebellum are the two areas involved. And we don't get emotional distress if we stump our toe. We may get some pain, but we don't get emotional distress. Those are the two areas of the brain that are affected by severe emotional distress. And I would suggest to the court that there is no profound injury one suffers more than the loss of a child. In this case, we have mom having a death wish for herself. She's had an inability to leave the home on any regular basis. She has preserved the child's room and all the child's clothing in one room. She dropped out of school where she was trying to obtain a degree. The husband quit his job, and the last I heard, which was fairly recently, she's still under the care of either a psychologist or a social worker. There are antidepressant medications that help, but they don't fix it. They just help.
Mr. Jackson, I don't think anybody is challenging the severity of their grief, but number one, how do you distinguish Gardner?
How do I distinguish Gardner? Gardner was husband driving a truck, apparently negligently, and running off the road into a bridge abutment. And that ties into the 3 factors which I set out, that is that, first of all, a bridge abutment is not a nuisance, attractive nuisance. It's not an ultra hazardous activity, and it doesn't violate any state criminal statutes. The thing that strikes me about this case is we have a state criminal statute which I believe was designed to protect children, and yet still right in the face of that statute, we've got a loaded shotgun with no safety, no trigger. I believe they call that a trigger. No trigger guard. I've never used one of those. I've always left mine unloaded. But anyhow, that's the three, I think, standards that we ought to take into consideration on foreseeability of this terrible happening. I look back on the cases starting in 1906 in Kimberly versus Howland, where our court found foreseeability when the fella at the Western Union didn't bring down a telegram that said his wife was in, the wife of the plaintiff was in extremis and he should come immediately, only to find out many days later that she had passed. And that case went forward on reasonable foreseeability, and that was in 1906. So, I mean, for a long time, North Carolina has had this tort, and it seems like Gardner and some of the other cases are trying to make factors into elements. In fact, that's pretty much what the dissenting opinion does. Off the record, I have lived through this, so I do have some knowledge of it. I think that what Gardner and what Ruark and Johnson, or Johnson-Ruark, are trying to tell us, that factors are not limited. Each case, it stands on its own.
So is it your argument, Mr. Jackson, is it part of your argument that the loaded shotgun, which you mentioned, left in the daycare in the presence of young children, should be a factor added to the Johnson list?
Yes. I don't think there's any bright line drawn as to what can and cannot be a factor. I think each case has to stand on its own merits as far as that goes.
Well, let me ask you something else about the factors while I've interrupted the flow of your argument. How do you think that the court in Gardner treated the factor of proximity and presence separately, if they did?
Well, they seem to have done so, and I have no answer to that. On Gardner, to me, if you get a call that says your son was killed in Afghanistan, it's going to have as much devastating effect on you as if he was killed in your presence. It's the loss of the child that causes the emotional distress, not the noise and seeing it yourself. Of course, in this case, I don't know that having a dead baby handed to you at the hospital with a fresh gunshot wound is any less traumatic than it would have been if she had been in the kitchen when the shotgun was discharged. As a matter of fact, if we want to be really technical, the human eye cannot follow the path of the shot itself. I mean, you can hear the noise and you can see a reaction, but bullets just travel too fast to actually see them. But I think that's just a petty point, but it is a fact. Well, I think to me, the main distinguishing points between Gardner and Johnson is in Gardner, we've got some negligence, but we don't have an attractive nuisance. Certainly a bridge abutment's not an attractive nuisance. A bridge abutment is not inherently dangerous, and the bridge abutment is not subject to a safety standard to protect children. And I think those are three factors right off the get-go that mitigate for foreseeability. If it wasn't foreseeable, we wouldn't have had the legislature enact the statute to protect children from weapons left where they can easily be accessed by kids.
Opposing counsel, Mr. Jackson, talks about the aspect of foreseeability in the cases that have been decided, and that if we would rule in your client's favor, that it would be an expansion of the foreseeability standard. Do you see this case as one where the court would be expanding foreseeability, or merely would be adding to these factors from the Johnson case?
No, I don't see that as expanding and clogging the courthouse dockets with NIED cases. These facts are pretty unique to this case, and the plaintiffs are parents. They're not second cousins twice removed. I mean, I think that's going to be self-limiting factor. It's going to be parents who bring these kind of cases and not just kin people or neighbors and so forth. So I do not see that as being a potential burden on our trial courts.
Would we be carving out an exception for the parent-child relationship in light of what some of the other cases have said about the fact that the parent-child relationship in and of itself does not yield an NIED claim?
No, we alleged in this case, and that they had a very close and loving relationship, and that justice is on paragraph 6, page 5, and more so on paragraph 28, page 7, where it lays out the relationship between this child and these parents. I really believe that an examination of the dissent by Judge Exum in the Gardner case is the proper law that we should have in North Carolina.
Are you asking us to overrule Gardner?
Not specifically. I think you can.
How do we adopt the dissent that Justice Exum wrote in Gardner without overruling it?
No, wouldn't ask that. I would ask you to just take a look at his dissent, and the reasoning behind his dissent, I think, is extremely well written and very close to reality and fact. Psychological factors are stress, marital problems, increased risk of suicide, pain, and guilt. And I have all of those in this case, the psychological factors. I don't know if they had those in Gardner. I couldn't tell from the case if those factors or those injuries were allowed. I think we need to remember that injuries to the brain is an injury to the whole person. It occurred to me when I was in the trial court that since the judge seemed to be centering on she wasn't there and didn't see it, was that if that's the case, a person who is blind could never bring one of these cases. So, all the senses are involved, particularly the senses of hearing and of touch. And I think those should certainly be spelled out. I don't know how closely you followed the pleadings on Mr. Gardner. He was a volunteer fireman, and he heard about the shooting of a child at a daycare center, and they gave the address, a female child, and he figured it was his daughter, and he headed there and followed the ambulance, and apparently, I put apparently, was able to hear the communications between the ambulance drivers and the people in the ER. If I said Mr. Gardner, I apologize. This would be Mr. Newman, who worked at the tire store. I think we've covered a number of factors, and the passage of the criminal statute obviously foresaw people being careless with firearms around children. Have I answered your question, or do you need me to?
Yes, sir, you answered mine. Thank you.
And mine as well.
Thank you.
Mr. Jackson, I have a question for you about the loss of consortium claim. Assuming hypothetically that we agree with you that the negligent infliction of emotional distress claim can go forward, can you talk about why we should allow a loss of consortium claim to go forward as well?
Well, the loss of consortium, I guess, if you have a wife who is telling you she would like to be dead and has the inability to do the things she was doing in this family prior to this child being slain, leaving a child's room exactly the way it was, start questioning God, and still going to psychiatrists or psychologists or social workers the years afterward. And of course, I guess we shouldn't be looking at that, but she continues to go. That would definitely interfere with consortium. I think it takes an understanding husband to be able to deal with that, and I'm not certain that that would apply to my client, Mr. Newman.
So the loss of consortium claim is based entirely on the a change in the relationship between Mr. and Mrs. Newman?
Yes. I can tell you something off the record, but I think it would be improper.
Thank you.
Yes, sir. if I'm allowed, I would like to reserve a few moments to speak in rebuttal of what my colleague might say in his rebuttal.
Actually, Mr. Jackson, you're not entitled to rebuttal, so if you'd like to finish your argument.
Okay, I won't reserve any time, but if you don't have any further questions, the complaint is, I guess it's sort of heavily fact-based, and the brief pretty well sets out most of what I've said today. So I would leave it at that if I don't have any further questions.
Thank you, sir. Mr. Charlton.
Thank you, Chief Justice. To just briefly respond to Justice Davis's question about the loss of consortium claim, the cases, some of the cases addressing loss of consortium that I've identified in my brief, page 15, the King case, Manley case, Stokes case, all those cases involved loss of consortium that one spouse experienced due to an injury to the other spouse. So it's questionable, at least to my mind, whether it's proper to have a loss of consortium claim, in essence, alleging injury to the spousal relationship when it's someone other than the spouse who's been injured. I don't devote most of my argument in the brief to that point, but I do think it is questionable, at least, whether a loss of consortium claim can arise when the injury is to not the other spouse, but to someone else.
Well, but if we have a claim for negligent infliction of emotional distress and one of the marital partners has been injured in a set of circumstances that would support the negligent infliction of emotional distress, hasn't the marital partner rather than in this case, the child been injured?
Yes, Justice Irvin, I believe that's correct. That the loss of consortium claim in this entire derivative of the NIED claim. So if one is allowed to proceed, they can both proceed. If the NIED claim falls, they both fall.
Okay, thank you. That was the way I had understood the situation, but I may have concerned I might have misunderstood you a second ago.
But I'm sorry, could you repeat that? I just want to make sure I heard that correctly. Are you saying, Mr. Charlton, if we allow the NIED claim to go forward, the loss of consortium claim should also go forward?
Yes, Your Honor, in the sense that it's derivative of the NIED claim.
Has our case law recognized the proposition that a loss of consortium claim can be derivative to an NIED claim?
Your Honor, I have not identified any cases that hold that, so it may be a new incident. I'm not sure whether there are any prior cases. I have not identified any that situation arose.
Thank you.
So just to sort of briefly summarize here, and applying the job foreseeability analysis, and again, I think the court's use of that term foreseeability is unfortunate in some way, because it's not foreseeable as we normally understand that word. But in applying that analysis, this court has time and again been presented with situations in which family members have brought claims for NIED without being in close proximity to or personally observing the negligent act. And time and again, this court has held that those situations do not give rise to viable NIED claims. So in other words, allowing the NIED claim to proceed under these facts would compel this court to overturn Gardner and probably also the Anderson and Hickman cases as well. I want to close with a brief quotation from Gardner. Because she was not physically present at the time of defendant's negligent act, plaintiff was not able to see or hear otherwise sense the collision or immediately perceive the injuries suffered by her son. Her absence from the scene at the time of defendant's negligent act, while not in itself decisive, militates against the foreseeability of her resulting emotional distress. In conclusion, we're asking this court to uphold the trial court's decision reversing, or rather the trial court's decision dismissing plaintiff's NIED claims, and to reverse the Court of Appeals decision. Thank you.
Thank you, Mr. Charlton and Mr. Jackson. Madam Clerk, would you recess us for the day?
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess until 9:30 tomorrow morning. God save the state and this honorable court.